I received a request from a subscriber on March 7th that suggested the following workplace scenario: how to conduct yourself while your workplace is under litigation as part of the management staff. My name is Nina, and I'm about to get in your business. If you would like to know more about business operations, please consider subscribing to the channel and clicking the notification bell to be alerted when new content is uploaded. Nikki, thank you for supporting the channel and being a subscriber. If you are a subscriber and a supporter of the channel, you can request a video topic just like Nikki did by writing your request in the comment section of any video. Just to remind everyone of the scenario, how would I recommend management conduct itself while the company is under litigation? I am not an attorney, but I do have my recommendations. In this scenario, I am assuming that your company was already served with litigation documentation and an experienced licensed attorney has been hired. Heed your attorney's advice. Discuss management behavior with your attorney and ask for advice as to what your management team should and should not do. Then, follow the advice of your attorney. Managers should document any known facts about the case as soon as they are notified about the lawsuit. For example, if it's a sexual harassment lawsuit, the managers involved should document what transpired that led up to the lawsuit filing. If it's a sales tax lawsuit, the bookkeeper and the company accountant should have all receipts, accounting software files, and copies of tax returns ready for the attorney to review. Preserve all related information, documents, emails, web pages, photos, videos, text messages, names of witnesses, if any, and voice messages. If you have a document destruction policy, I recommend suspending it until your company has discussed this with your attorney. In addition, if appropriate, take pictures and/or video and be sure to include identification of time and date of the images. Review your company's confidentiality agreement as well as your company's employment policy on confidentiality. This will ensure that your management team is reminded to refrain from discussing business that is not in the public domain. Managers and employees should not speak about the lawsuit to anyone. That includes other employees, friends, and spouses. Do not discuss any litigation issues with strangers or anyone who may approach you in any chatty manner asking about the company. This could be a detective looking for an employee who may have information that could benefit the plaintiff. Any information discussed with another colleague uninvolved in the litigation could also mean that that colleague could be called as a witness for the plaintiff, depending on what was discussed. Managers, employees, as well as the business owner should not talk to the plaintiff once litigation papers have been filed. This includes managers or employees who may be friends with the plaintiff. If you must speak with the plaintiff due to a business link, I highly recommend relaying messages through your attorney's office. You never know who may show up at your office asking questions about the litigation proceedings. Informants for the plaintiff, the media, you just don't know. I recommend designating a spokesperson. Direct anyone who asks questions about the litigation to your company spokesperson. The person designated as the spokesperson should be coached by your attorney and provide pre-written answers to any questions. My recommendations on approaching any questions would be that any request for information be made in writing. That way, the spokesperson can select words carefully and CC all correspondence to your attorney and other related parties. Keep emotions in check. Being named in a lawsuit is a serious thing. The last thing a manager needs to do is fuel the fire by projecting aggression or anger towards the plaintiff or current employees. If a company is being accused of wrongful termination, for example, litigation can sometimes open up a manager's expertise to scrutiny or the lack of business processes your company has. Do your best to maintain a calm demeanor and correct any corporate inefficiencies. It's scary to think of, but some lawsuits may occasionally leave plaintiffs to recover financial losses from supervisors, managers, and HR directors. The following states as of 2018 allow plaintiffs to bring claims against an individual under the aided and abetted theory for harassment and discrimination: New Jersey, New York, Massachusetts, Connecticut, Ohio, Oregon, Pennsylvania, and Washington. In California, plaintiffs may bring claims against individuals who retaliate against them for engaging in protected activity. Under federal law, individuals are regularly found personally liable for violations under the Fair Labor Standards Act, Family Medical Leave Act, Section 1981 of the Civil Rights Act, the Uniform Services Employment and Reemployment Rights Act, the Employment Retirement Income Security Act, and other laws. Check your insurance policy for coverage. Companies should conduct an annual insurance review to ensure that you have active, proper coverage. Hopefully, this review is performed prior to any litigation. For more information on performing an annual insurance audit, please watch my previous video on this topic. There are some laws that all managers should know at the minimum. Training will act as a corporate defense in the event of a lawsuit as long as you train in the area in which you are being sued. Not only that, managers will know that they may be held personally liable for violations of state and federal laws. Educate managers on the various federal, state, and local laws that govern your business and related areas. Ignorance of the law is not a defense. Do not ignore employee complaints. Do not apply employment policies inconsistently. Do not get lax when it comes to documentation on employees and events that happen at your company. Take proactive steps to create a strong HR foundation that includes creating or updating your handbook, delivering anti-harassment and anti-discrimination training to all employees and management, creating a detailed complaint procedure that is published to all employees, and providing management training on dangerous areas such as interviewing, discipline, and terminations. This video covers my basic recommendations on management behavior when a company is under litigation. I can't say it enough. My best advice for any company when talking about litigation is to regularly train managers to reduce the chance of any litigation against your company. Thanks for watching.